From a man who stubbornly kept harassing and bombarding his ex with messages, ignoring court orders.
The core problem here is Mr. Newell needs to stop messaging the victim. That's what the contacts have been. I think that 30 days jail is a lot. If he continues to contact her in the future by phone, it's going to result
to another facing charges for public disturbance while intoxicated.
Judge, Mr. Thomas was extremely intoxicated that night, and eventually the police told him to put his hands behind his back, and he said, "What for?"
These cases show Judge Melissa Morgan's no-nonsense approach to accountability, starting with Mr. Newell, who nonchalantly thinks he can play games with a restraining order and keep harassing his ex with no consequences. Let's see how that works out for him.
We will go on the record in the matters 25 CM 22 and 23, State of Wisconsin versus Zachary Newell. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Newell in person with counsel Daniel Chapman. We're set today in these matters for a plea and sentencing. Mr. Chapman, can you please provide the agreement on the record?
Judge, Mr. Newell will be pleading to count 1 in 25 CM 22. That would be knowingly violating a restraining order. There's a joint recommendation for time served and court costs. I believe he has 30 days credit.
All right, is that
The
stipulated
other
too?
case is being dismissed and read in.
That's what I calculated too.
All right. Mr. Newell, that's the agreement you've reached?
Yes.
I have in front of me a plea questionnaire waiver of rights form. Do you recognize that document?
Yes.
Did your attorney go over that document with you?
Yes, ma'am.
Did he go over it thoroughly with you?
Yes,
You understand everything on this document?
I do.
And if you didn't understand something, he did explain it to you?
Yes,
And that's your signature on the second page. You're pleading guilty to one count of knowingly violating a domestic abuse temporary restraining order. Is that correct?
correct.
You are 32 years old. You have 12 plus years of schooling. You can read, write, and you understand the English language.
Yes,
Your attorney went over with you what the state would have to prove your guilt beyond a reasonable doubt, as well as the maximum possible penalties you face.
yes,
No mental illnesses or disorders, no drugs, alcohol, or medications.
no,
Your attorney went over your constitutional rights with you. Is that correct?
yes,
Do you need me to go over those rights with you in any more detail?
no, Your Honor.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes, I understand.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Okay,
Do you understand that?
I understand, yeah.
Do you understand that here, the state would have to prove on or around January 26, 2025 in Burnett County, Wisconsin, you knowingly violated a temporary restraining order ordering you to refrain from committing acts of domestic abuse against the petitioner to avoid the petitioner's residence, except as provided in paragraph AM or any other location temporarily occupied by the petitioner or both, or to avoid contacting or causing any person other than a party's attorney or a law enforcement officer to contact the petitioner unless the petitioner consents to that contact in writing or any combination of these remedies requested in the petition or any other appropriate remedy not inconsistent with the remedies requested in the petition. Do you understand what the state would have to prove?
Yes.
You understand that upon conviction, you do face a fine of up to $10,000 or imprisonment of up to 9 months of incarceration or both?
Yes,
Do you understand that the recommendation here is for 30 days of jail plus court costs and fees?
yes,
You understand I'm not bound to follow that, meaning I could sentence you all the way to the maximum possible penalty if I thought it was warranted?
yes, I understand.
Do you still wish to proceed and enter a guilty plea?
Yes,
Did your attorney go over that criminal complaint in the probable cause section where it basically says what happened and why you were charged with the crime?
yes,
For the most part, are the facts accurate?
yes,
Are you admitting here today that you did in fact knowingly violate the domestic abuse temporary restraining order?
yes,
Mr. Chapman, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty to this charge?
no,
You're doing so freely and intelligently, telling the court you fully understand what you're doing today
yes,
and voluntarily?
yes,
Has your attorney represented you competently?
yes,
Has he answered all of your questions?
yes,
Has
yes,
he looked at this matter thoroughly?
yes,
You're satisfied with his services?
yes.
Any questions for the court or for your attorney before we proceed?
No,
As to the sole count in 25 CM 22, how do you wish to plead?
guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of that sole count. The other case will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
Thank
First,
you.
are we in victims' rights compliance?
Yes. Thank you, Judge. The core problem here is Mr. Newell needs to stop messaging the victim. That's what the contacts have been. She's told him no, she's gotten the restraining order. I believe for one of these, it was the temporary restraining order. The restraining order is fully granted now. I think that 30 days jail is a lot for somebody doing just messages over the phone. I think it's appropriate in this case. I think that that will communicate to Mr. Newell that if he continues to contact her in the future by phone, it's going to result in jail. Thank you.
Not an assessment, just
Mr. Chapman.
Judge, there was a messy breakup here, and as Mr. Newell told the cops, he just kind of lost it when she started accusing him of things, and he was upset. He sent a whole bunch of text messages in a row. I don't believe there's been any contact in a decent amount of time now, and I think the relationship is over. He did tell me that he went to alcohol and drug counseling through Aurora since this case has been charged. I think given the fact that the restraining order is in place and he did a month of jail, I think that's an appropriate resolution for this crime. He does have a prior deferred agreement in 2019 and a meth conviction in 2022 that he successfully completed probation for.
All right, thank you. Mr. Newell, is there anything you want to add or you want to state today?
no, Your Honor.
Thank you. This is a more serious case in the fact that it is a temporary restraining order in which an individual went to a court and asked that you stop contacting, you stop having any contact with her, and you violated that temporary restraining order. So it does make it more serious, and especially because it's a restraining order. You did sit a significant amount of jail, and I'm hoping that that was enough time for you to think
Yeah,
about your actions, and I think it have.
yeah,
And you understand that if you do it again, there could be even more severe consequences that you face. There is absolutely no contact with the individual in any way, shape, or form, not even through a third party,
understood.
unless it's through that individual's attorney or from your attorney to her attorney. I do believe that this is an appropriate resolution. Even had you not sat the jail up front, this most likely would have been the resolution, but you ended up sitting the jail up front. So you already have that sanction done. I believe that in all respects, the individual is protected. There is now an injunction, a permanent restraining order, and there won't be contact, and you have been punished. So the
Yes,
court will follow the recommendation, 30 days of jail, court costs and fees in the amount of $500. You have that posted. You are good to go. This is a time served. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I do need to order your DNA. Once you're done here, you'll go to the sheriff's department. You'll provide your DNA.
Okay.
And once you're done there, you are to go. You have the ability to request it be expunged through a written letter to the Department of Justice. That's who you ask, not this court or this county, through the Wisconsin Department of Justice.
okay.
I believe that covers everything, Mr. Schmidt.
Nothing for me.
Mr. Chapman.
Nothing else, Judge.
All right. Good luck, Mr. Newell.
Thank you.
While Mr. Newell got a permanent restraining order he deserves for harassing his ex, now it's Mr. Wilhelm, giving different excuses for late payments, left to figure out how to pay back $17,000 in restitution for his crime. Let's see how the judge handles this.
In the matter 15 CF 83, State of Wisconsin versus Devin Wilhelm. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Wilhelm appearing in person without counsel. We're set here today in this matter for a review hearing. You're here because, Mr. Wilhelm, you owe a significant amount of fines, fees, and restitution. I'm pulling up the order right now. It is well over $15,000 that you still owe. Are you currently working?
Yes.
Where do you work?
Cedar Ridge Treatment Center in right outside of Stillwater in Minnesota. It's a little township. I can't remember the name.
Okay, and how much do you make an hour?
19.
19,
Yeah.
and you work full-time?
Yes.
All right, and why haven't you been able to make payments or pay this off yet, since it's been a significant amount of time?
I believe I have been making payments towards it. I think the last time I was in court, it was 2 months at $100, and then it was going to go up to 200 after that. And I know there has been, like, I was late with the payment and then got caught up and then made the payment since then.
All right, yes, I'm looking at, it was a long time that you missed payments,
Yeah.
and then we got you back
Yeah.
when the court issued that warrant back in December,
Yeah.
and you made that $1,000 payment, and then you've been trying to make that $200 payments, and you're gonna be working your way up with that, okay?
Yeah.
Yep, okay. Now you've been making your $200 payments,
Yes.
and so far that's been working. And I think there's actually $17,000 that's owed.
Yeah. Yes. I think in total it was 17 and some change, I believe. I don't.
Yeah, okay, 17,000. Wowza. At $200, it would be 77 years to pay it off. So we're gonna have to look at something a little bit more aggressive to pay this off in a quicker fashion, since this is an old case. And if we're looking at the restitution order, there's one individual that is owed a significant, all of the restitution. What are you thinking? Are you able to pay this $200 for a significant amount of time, or for the summer and then increase it? Or what are your thoughts? You know your finances at least better than I do at this point. Did you
I
fill out a
mean-
financial review?
No, I didn't know that was something,
Okay,
an option or something I needed to do. I mean, I'm able to pay the 200. If it needs to go up, I can, try and make it work. Obviously, if it goes up, I have to.
are you paying
So-
rent or a mortgage?
So I'm paying $750 for rent every month at my sober house.
Okay,
I've got insurance, $200 a month for car insurance. But I'm paying 300 out of every paycheck towards, it's not court obligated child support, so I don't even know if I can put that on the
300 a
record.
month?
300 every 2 weeks for child support.
How many kids?
I have 2 kids. I'm paying child support for one, and I'm currently with the mother of my other child.
Okay.
So
Well, you're supporting your kids. That's
trying
positive.
to. It's more than I've been doing in the past.
No, I
So
want to hear that. Even if it's not court ordered, I'm even more thrilled and excited that you're doing that. You're being very responsible.
yeah, trying to be compared to what I was in the past.
You're doing the right thing. All right, so you have your $750 in rent for your sober house, $200 insurance, $300 every other week, so $600 a month in child support. Your sober living place, is that where your other child and significant other, they can live with you?
No, my significant other has a house in Oakdale, and my daughter lives there with her.
Okay.
Yeah.
All right, and any other expenses? Or do you help her out too? I know you're with her, but she has other expenses now with the
Yeah,
child?
yeah. I mean, like $200 a paycheck
Okay,
is towards food, and then I don't really know how to add up the other stuff. It's just, hey, we need diapers, we need food,
okay.
anything else. And then I really haven't been buying much food for myself, so I'm not sure what my other expenses are.
Okay,
I
so how
know,
long have you had this job?
going on 2.5 months.
Oh, that's good. That's
believe.
great. Okay.
Yeah,
So it's been consistent for 2.5 months and you're trying to stay there, be consistent and build something. That's good.
yeah.
Okay. And are you on Price Avenue? Is that where you are?
So that's my mailing address.
That's your mailing address.
Yes.
And what is the address where you are actually residing?
858 Point Douglas Road South, St. Paul, Minnesota, 55109.
And that Price Avenue, that is your significant others?
That's my father's address. Yeah.
Okay, all right.
Yes, and then I also have a new phone number if that needs to be updated.
Yes, please.
All right. Just give me 1 second. So I mean, I guess that is also another expense is $100 a month for my
For
phone
phone.
bill. Because before that I was getting, it was like one of the Obama phones, 612-750-5267.
Maybe send you text messages if we need to?
Yes.
Okay. Well, here's what I'm hearing. I'm proud of you for doing what you're doing, having your job, being consistent, and now starting to pay child support, even though you're not court ordered to do so. That's a big thing. You're being responsible for both children, all right? Even when you're not ordered to do so or forced to do so. And it's a good amount of money that you're helping to support, and that's good. You're in a sober house. You're continuing to remain sober, and that's positive. You are being responsible, paying your car insurance, and working full-time. I will continue the $200 a month. What type of job is this? Is this a full year-round job?
Yeah, it's not seasonal. It's like a recovery specialist. Yeah.
Okay. And this is something that you want to do as a long-term goal?
I'm not sure. I don't see myself leaving anytime soon. I know this was just my goal was to get a job at a treatment center just to get back into the workforce and then maybe get back into construction or the trades or go back to school. Just
All right.
yeah.
Well, I'm gonna say that continue the $200 for 6 months, and then it'll increase to $300, and we'll see how you're able to handle that, okay?
Okay.
It gives you some time to get stability, to pay your bills, to be responsible, then it'll increase to $300. Even at $300, it's still gonna take a significant amount of time to pay all of this off, but it shows that you are doing that and you're being accountable and you're putting a good faith effort towards making that payment to pay off all of this restitution. I'm not so worried about the court costs and fees. I'd rather focus on that restitution and have the victim made whole, okay?
Yeah.
And so that's what we're gonna focus on. If it comes to the point where you're making that $300 a month payment and it's too hard and you're having a significant substantial financial hardship, then write a letter to the court. You're gonna need to fill out that financial sheet that I told you about. It talks about all of your bills, all of your income, those types of things, and you file it with the court and we'll go over it to see how much a payment you can afford. But you're gonna have to be very cautious because sometimes I do look at that form, we go over it, and I actually increase the amount because we find money that you could have towards the payment.
Yeah.
So be very careful with that. If you do switch jobs and go to a different job, call the clerk's office, notify the clerk, and we can update our records with that. Is this an income assignment? Are we taking it out of your paycheck?
No.
Would you like that to happen? Because we could do that. If you'd like that to happen, and if that's easier for you, you could stop at the clerk's office and they can go ahead and do that. Then you wouldn't have to worry about that. It could come right out of your check.
I don't know. It's kind of been working.
That's fine,
Just
as long
calling
as
up and
it
making the
works and as
payments.
long as it's good.
Yeah.
Because once it stops, if it stops, and I don't get a payment for a month, I will issue another warrant
Yes.
and that won't be good. Okay? All right. Do you have any questions?
If I do need it, where do I get that financial?
From the clerks. You would
Okay.
call the clerk's office and then they can send it to you or get it to you somehow. Okay?
Okay.
All right? Anything else?
Is there gonna be another court date or is it just?
I'm not going to set one right now, just
Okay.
if you think you need one in the future, if you're unable to pay. Okay?
Okay.
But if it comes a time and let's say you get a raise or you come into, you go and you buy a lottery ticket and you win $2,000 and you have extra money, I would look at paying this down a lot quicker and faster, paying an extra $500 a month than getting, if you win extra money or you get a gift or something like that. So you can get this paid down as quickly as you can. Okay?
Yeah,
You don't want it hanging over your head for the next 7 years.
I definitely do not.
All right. Then we are adjourned.
Thank you.
Finally, our last case here is focused on Judge Melissa Morgan dealing with a disorderly conduct charge where Mr. Thomas turned a drunken night into a violent outburst, punching walls and screaming at cops. Let's see how the judge handles this.
We will go on the record in the matter 25 CM 16, State of Wisconsin versus Todd Thomas. The state appears through District Attorney Kevin Schmidt in person. Mr. Thomas appears in person with counsel Daniel Chapman. We're set today in this matter for a status conference. However, the parties have reached an agreement and have asked the court to move forward with a plea and sentencing. Mr. Chapman, can you please update the court and provide the agreement that's been reached?
Judge, Mr. Thomas will be pleading to disorderly conduct, and there's a joint recommendation for 3 days jail, time served, and court costs.
All right. Basis for that agreement, Mr. Schmidt.
I think it's appropriate with the jail and the costs. The victim's not requesting anything. His criminal history is minimal. It's his only criminal conviction's a driving offense in Minnesota. That wouldn't be a crime in Wisconsin.
All right. And that's the agreement you've reached, Mr. Thomas?
Yeah.
I have in front of me a plea questionnaire waiver of rights form. Do you recognize this document?
I do.
Did your attorney just go over this document with you?
He did.
Did he go over it thoroughly with you? Essentially word for word?
He had to help me out with it a little bit.
But then once he did, you understand it completely?
Yeah.
And you signed that document?
I did.
And so you're pleading guilty to 1 count of disorderly conduct. Is that correct?
Correct.
You're 24 years old. You have 12 plus years of schooling. You can write. You understand the English language. Your attorney went over with you what the state would have to prove your guilt beyond a reasonable doubt and the maximum possible penalties you face.
Correct.
And you are not receiving treatment for a mental illness or disorder, no drugs, alcohol, or medications, correct?
Correct.
Because you're charged with crimes, you are entitled to constitutional rights, and each of the rights is listed on this document. Your attorney went over these rights with you, is that correct?
That's correct.
And do you need me to go over these rights with you in any more detail?
You do not, Your Honor.
And you understand that by pleading guilty, you're waiving and giving up those rights? Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yeah.
Do you understand that the state would have to prove as to count 3 disorderly conduct that on or around January 20th, 2025 in Burnett County, Wisconsin, while in a private place, you engaged in unreasonably loud or otherwise disorderly conduct, which under the circumstances tended to cause a disturbance, a Class B misdemeanor. Upon conviction, you face a fine of $1,000 or imprisonment of up to 90 days of incarceration or both. Do you understand what this would have to prove in that maximum possible penalty?
I do.
And the recommendation to the court for 3 days of jail time served and costs?
I do.
You understand, I'm not bound to follow that.
Yeah.
I could sentence you all the way up to the maximum penalty if I thought it was warranted. Do you understand that?
I do.
And you still wish to proceed and enter a guilty plea?
Yeah.
Did your attorney go over with you that criminal complaint and there's a probable cause section that basically says what happened that day and why you were charged with these crimes?
Yeah.
For the most part, are those facts accurate?
I believe so.
And so you're admitting here today that your behavior and conduct that day tended to provoke a disturbance?
It did.
Mr. Chapman, may the court find that the probable cause creates a factual basis?
Yes, Judge, in the complaint.
Thank you. Has anyone made any threats or any promises to you for you to plead guilty to this charge?
No,
You're doing so freely and intelligently, telling the court you fully understand what you're doing
that's correct.
and voluntarily?
Yeah.
Has your attorney represented you competently?
Yeah.
Has he answered all of your questions?
Yes,
Has he looked at this matter thoroughly?
I believe so.
Are you satisfied with his services?
Yes,
Any questions for the court or your attorney before I proceed?
I do not.
As to count 3, disorderly conduct, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I will find that you understand your constitutional rights and what it means to waive and give up those rights. I will find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 3. Counts 1 and 2 will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
Yeah, reincorporating my earlier statement, 3 days jail is a significant penalty for a young person who does not have significant history at the system, that being a driving offense in Minnesota. I think that's a suitable punishment for this. Thank you.
All right, Mr. Chapman.
Judge, Mr. Thomas was extremely intoxicated that night, and he had punched the drywall in his mother-in-law's house, injuring his hand. They called for an ambulance. I don't think anybody wanted him to get arrested that night, but he was refusing EMS, shouting things. Eventually, the police told him to put his hands behind his back, and he said, "What for?" It was a night when he was extremely drunk, Judge. He has fixed his mother-in-law's wall himself, so there's no restitution to be requested here. And as the state indicated, he's young and has no record. He served 3 days jail over this, and I think that's an appropriate penalty.
All right, Mr. Thomas, do you care to make a statement here today? You don't have to, but it's your only time to let me know anything you want me to know.
He kind of just said it. He just went over it at the end.
Okay. This is not a very serious case. It just essentially was a night that went wrong. And you're doing what you need to do. And it sounds like you regret the situation and you tried to rectify it and make it better. So that's positive. You don't have a significant history. Hopefully you're not going to engage in this type of conduct again. Hopefully you learned a lesson. I think that the agreement is appropriate. I will order 3 days of jail, $443 in costs and fees. You have $500 posted, but the rest will go towards your attorney's fees because this is a court-appointed attorney. I'm not sure how much the bill is going to be, but Mr. Chapman is a very good, efficient biller. So once we get the bill from Mr. Chapman, the money that you've already had down, plus that extra money will go towards his bill. If you owe anything else, the bill will be sent to your Danbury address and you'll be notified, okay?
Can I switch my address?
Oh, yes, you sure may.
Our house just burnt down.
Oh, I am so sorry to hear that.
Yeah, that kind of sucked, but can I use my old address? I was living in Sandstone.
Yes,
It's 1122 Highway 23 North.
Sandstone.
Yep, Sandstone, Minnesota.
And is it still 2387?
Yeah.
Okay. Can we send you text messages if we need to?
Yeah.
Thank you. All right. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I need your DNA. When you're done here, you're going to go to the sheriff's department and see if they need that. If they do, they'll swab you. If they don't, they'll send you on your way. You have the ability to request it be expunged through a written letter to the Department of Justice, not to this court or this county, to the Wisconsin Department of Justice. It's easy to do. You can Google it or ask your attorney. He can help you with that. If you fail to pay off your attorney's fees, you could get a warrant, but make sure you get it paid off. Again, I don't think you should have anything entirely substantially outstanding. Again, Mr. Chapman's a very good biller. Mr. Schmidt, am I missing anything?
Not for me.
Mr. Chapman?
No, Your Honor.
All right, then we are adjourned. Thank you.
She'll give you some paperwork, and if you could hang out in the hallway for a second.